Okay, this is part 3 of this order. Okay, paragraph 19. I think I only got through 2 paragraphs, maybe, that last hour. According to Dr. Berryman, the visits with the mother have not gone well, and that is not true. I've talked to Dr. Berryman, and she tells me, oh yeah, Dolores says the visit went well. Dolores said she had a good time with you. The only times that the visits have not gone well were the times where the police were called, and then before Latasha did that Tracy Rose, who was very much intimidated by my daughter's dad, and she was afraid I was talking about something. I think it was when I was we were getting ready for trial, and I had subpoenaed Delara because I felt like she needed to be there. And she told me before she wanted to talk to the judge. So I had subpoenaed her, and I think they're trying to quash the subpoena. And I asked, and I didn't want to force her to come, because even though she'd said before she wanted to come talk to the judge and tell the judge what she wanted, if she changed her mind, because she was having a lot of anxiety. And I'm like, well, I don't want to push her, and I'd rather just not have her if she doesn't really want to come. So I asked her if she wanted to come, and she said she wasn't sure. And I wasn't talking about court issues in court. I was just saying, well, if you do, the judge will probably just take you back in her office, and just you and her talk. It shouldn't be anything scary. It's like the guardian ad litem talking to her, or or DCS. I mean, that's all I said. I wasn't saying, I wasn't talking about court issues, but I needed to ask her about that. And then Tracy was like, oh, I don't know if you're supposed to talk about that or not. And she called her supervisor, and she kind of freaked out. And then she said, I'm going to have to end the visit. And I don't know why she was just really nervous. And because she had said that they threw Judy Mullins under the bus for not, for arguing with, not going along with Dolores' dad. So Tracy's trying to not make her Dolores' dad mad. So, so we got past that. I said what I needed to say to my daughter, and got her answer I needed to get. And I don't believe that was a violation of the court order, because I wasn't talking to her about proceedings and stuff. I was just talking about something that would be affecting her, because I didn't want her to come if she didn't want to. And yeah, and then but Tracy was so paranoid. She's like, well, she kind of sort of touched on court, but how can you? That would be very easy to touch on court. Well, I don't know when I'll get to see again, or I don't, There was nothing I said about court that I didn't really directly mention court at all. That's the only thing I remember, is asking her if she wanted to talk to the judge, and if she didn't want to, that's all right. But yeah, so that visit was a little bit nerve-wracking, because and Tracy eventually says, I'm not going to end the visit because I know Delara needs it, and I'm not going to do that to her. And I'm like, well, thank you, and Delara was starting to stress out. She kind of went and kind of stormed off. It's like, so it was we had a few minutes there that weren't, and then we finished the visit, and the rest of the visit was fine. And that's what everybody, that's what was in the record, is that, we had a few minutes, and it went fine. And but Tracy was afraid of getting in trouble, and so she asked this other person to do it, and then her supervisor, and the supervisor was just done with both of us. So she made sure that they weren't going to be involved in this stupidity anymore. But this is not true. According to Dr. Berryman, the visits with the mother have not gone well. She could have said, not every visit went well. But she really should have said, almost every visit has gone well. Or the child enjoys visiting her mother. Because Dr. Berryman, Dr. Berryman was on telephone on something, and it was raining, and we could hear the over the telephone, and I couldn't really hear exactly everything that was said. But based on my conversations and emails with Dr. Berryman, Delara enjoyed the visit. She looked forward to the visits. They were good for her. Dr. Berryman felt like Delara should be seeing me, and should be seeing me more than she was seeing me. So I'm just telling you how biased this judge is. And Dr. Berryman, when I do my motion to alter or amend, I'm going to try to get Dr. Berryman on the phone to clarify her statement so the judge can alter or amend. The child particularly talks, let's talk about with Dr. Berryman, the child particularly talks about the time when the lady called the cops for no reason and another time when the visit was stopped early. Okay, so that's 2 times out of 2 hours, out of like 8 hours. We had like 8 or 12 hours a month. So we've had basically 2 hours out of like 85 hours that were bad, and all the rest were good. Very good. But what do they focus on? She acts like they're all bad. Furthermore, yeah, there's like, oh, the visits with the mother have not gone well, especially these 2 visits. Instead of saying they've all gone well except these 2 visits, she says they've all not gone well, especially these 2 visits. So, furthermore, there was testimony that the child takes on the role of trying to protect her mother when they are together. Dr. Berryman never said she has observed anything of that nature. But she's putting in this paragraph where she's talking about, that was a report made by Latasha. I'd have to go back and listen to the video, but Dr. Berryman has never indicated to me that she feels like Delara's trying to protect me. So that's just crap. The counselor, the psychiatrist, she meant psychologist, Dr. Berryman, I think, nor the visitation supervisor for Camelot, Latasha Stevenson, who did that one bad visit with Camelot, believed that the visit had been improving the child's emotional state or behaviors. And again, why would you expect these? I mean, and it's stressful. The supervised visits are not. I don't care how nice your visitation supervisor is. It's not natural. It's not natural to have people sitting there watching you interacting with your mother, listening to every word and taking notes. That's not a normal, healthy interaction, and you can't. It's unreasonable to expect a child to respond to that situation where you're getting 2 hours a week in this very controlled environment. You can't compare that to being free to pick up the phone and call your mom when you're with your dad, seeing your mom face to face every day, having unrestricted access to your mom. That's what she had before. So it's just, I really hope that when I do this motion to alter or amend Dr. Berryman, and I'll have specific questions to ask her to clarify her previous statements. Because I guess I can't ask her new stuff unless I get the proof reopened, which I kind of would like to do because there are new concerns on her IEP. Delara, last year in first and second grade, she was very violent. But this year in 3rd grade, she's more, it's more, like in the IEP, it's like what is it? Abusive self-talk, maybe, or verbal self-abuse, thinking she's bad, thinking stuff's her fault, wanting to be dead, or life's miserable, why, and they've had mobile crisis that's come to the school September 2018, 17, close to the beginning of this third grade year, because she wrote a note that said, "I wish I could die and come back as nothing. I always feel sick. I'm always in pain." That's one I know about. And the only way I knew about that is because he brought it up in court trying to say the mother did something to cause the child to do this. And then there was another thing they brought to court in February. And see, these are just the things I know about. I don't know about the things he doesn't tell me about. And I certainly don't know about the things that happened when she was not seeing me. Because if bad things happened when she was not seeing me, that wouldn't benefit him. Because he wants to say, oh, she was great. So if I'm seeing her on this limited basis and bad things happen, he tries, and he does. And the judge apparently buys it. Says it's because she's seeing me. And it's bad for her to see me. But yeah, she wrote in her agenda, and she's told me, she's like, well, because I asked her one day, she's just, she's like, she had a meltdown and was telling her principal, just kill me. And I'm like, and then when I talked to her a few days later, I said, well, how was your week last week? And she said, oh, it's fine. And I'm like, well, what about Friday? In the bathroom with the principal? And she says, well, I was just really sad that day. And I'm like, well, why were you sad? And and I've got this recorded on a phone call, this conversation where she's telling me this. So I might not have it verbatim, but I've got it close to it. And she said, well, there's not really much point in life when you don't have family. And when you don't have a mother. And I'm like, well, you mean you see so little of me, you feel like you don't have a mother at all? And she says, yeah, pretty much. And I got that, her words on, yeah, but, so if we reopen proof, I could get that in there, I guess. But, that's just really sad. And Dr. Berryman, I told Delara, I said, Dr. Berryman thinks you're happy and fine and nothing's bothering you. And Delara says, well, that's not true. I'm like, well, that's what she sees, because she's got a good rapport with Dr. Berryman, and she goes there and has a good time, gets this one-on-one attention for this motherly figure, and they play games like, Delara that I used to play games. And so that's like happy time. And even Dr. Berryman says we don't talk about feelings. She doesn't, and I don't want to push her because she doesn't want Delara to have a meltdown in her office and then she has to send her home with her dad all upset. So it's not really not therapeutic. And I mean, I'm sure it's fun she enjoys it. Delara enjoys it. So I'm glad for her to do that. And then sometimes when things come up, I ask Dr. Berryman, well, can you try to find out about this? So, so Dr. Berryman doesn't get, all this bad stuff from Delara, but I do share what the school says. So, I just don't, I think Dr. Berryman, but she does say that, she doesn't have any reason to think that me having maximum parenting time possible or going back to the old schedule would be detrimental to Delara in any way. She can't say that. She never has said that. And I think I even asked her, would I present a threat of harm? Would it be in Delara's best interest to not have a close and continuing relationship and maximum parenting time? And she, in her opinion, Delara needs to see me as much as she can. So, yeah, we might need to get some clarification if the judge misunderstood Dr. Berryman's testimony. Okay, despite the court order requiring mother to have supervised visits, there were several occasions when the mother went to the child's school to have lunch with her child. That's not true. I had lunch with her one time, and then her dad went and got that restraining order. So, I went the second day, but she wasn't there. I had lunch with her one time. So the most she could say was she went twice. Twice is not several. You have to have more than two to be several. And that's what she says. There were several, despite the court order. And I already mentioned earlier how the way the order was written, nobody other than the lawyer and whoever the lawyer, like the judge, judge, because it's not the way she wrote it. I don't care if she intended it to be different. It's not the way she wrote it. So she shouldn't, saying despite the court order, because they're trying to say that I was disobeying the court order, and I wasn't. I wasn't disobeying the court order. And the appeals court would agree with me. Due to mother's behavior, the Third Circuit Court for Davidson County, Tennessee at Nashville extended the previously granted order of protection against mother on behalf of the father. And that's bogus too. I never violated the order of protection. Her dad feels harassed by me because I continue to try to get my daughter back. I'm not walking out of her life. And I complain on Facebook. But that's not me contacting him in any way. When I say, and I don't even think I was referring to him by name, I was not violating the order of protection. He's had me arrested 3 times for violating the order of protection. 2 bench trials, I was acquitted because I didn't do anything. And then the third one, they just dismissed it. Actually, I don't know if it was in that order, but 2 out of 3 I had bench trials. 1 out of 3 the DA the prosecutors dropped it because I didn't violate the order and they couldn't prove I did because I didn't. But I did go to jail for it. I went to jail for all those things. Yeah, when they arrest you, you go to jail until you're bailed out. And the longest I've been in jail for anything, I've been in jail for as little as just a few hours to 3 days and 3 nights. Like Jonah was in the belly of the whale for 3 days and 3 nights. So that's the longest I've been in jail in one stretch. But I've been arrested 6 times. And all of the charges I've been arrested for have been false. They've been, yeah. So, no convictions. Okay. Now listen to this. Due to mother's behavior, okay, so they extended the order of protection, which I started to appeal it, and then I dropped the appeal because I thought they were going to let it expire, because if you have an order of protection that expires, there's not really anything to appeal if it expires before the appeal's done. So I thought they were going to drop it. They filed this motion to extend it like the very last day after I dropped my appeal. So okay, so here's what's interesting. Due to mother's behavior, they don't say what behavior the order of protection was extended for. But I didn't violate the order. And I told the judge, I said, he's accused me of violating the order. You can't extend this order if I haven't violated it. And he's accused me, he's had me arrested 3 times for violating it. And I've never been convicted of it because I did. And here's what Judge Philip Robinson said. And that man needs to be kicked off the bench for doing this order of protection between me and my daughter. I don't care if he did it between me and my daughter's dad, because I would be glad to not have contact with him as long as it accommodates the juvenile court order, and we can. But as far as me trying to engage in joint decision making, that's not possible, and I accept that. So he said, I told the judge, I said, he's had me arrested 3 times, and I've been acquitted. Or they dropped the charges because I didn't do anything. And then Judge Philip Robinson says, well, that's a higher standard of proof. So he felt like, because my daughter's dad feels harassed because I still want my parental rights back, even though I haven't violated the order of protection, simply because my daughter's dad feels harassed because I continue to try to get my parental rights back, even though I'm not contacting him, I'm not violating the order of protection. The judge says because he feels harassed, what you're doing makes him feel harassed, so I consider that a violation. So I'm extending this order of protection for 5 years. And I did have a lawyer. Before they did this, I did retain Connie regularly. And she wasn't there that day. And she asked me, she said, you want to get a continuance? And I said, no, because I don't care if there's an order of protection just between me and him. I haven't seen my daughter in a year. And when they filed to extend the order of protection, they did not put my daughter on it. So I was waiting to see my daughter, and if we got a continuance, it would have been another 2 or 3 weeks with me not seeing my daughter. So I told Connie, yeah, I'll just go myself. And because they're not going to be able to put Delara on it because they specifically said we're not asking for the daughter to be on it. They're only asking for between me and the father. So I didn't get a continuance so Connie could be there. And I don't know how it would have turned out, but my daughter, I was just glad my daughter they weren't even trying to put my daughter on it. And I think but if I hadn't had Connie, I think they would have tried to. So, okay. So this order of protection, it says, due to my behavior, they extended the order. And then the other part of the paragraph here, the next sentence says, mother's behaviors included throwing decorated rocks, saying free Delara, in the children's playground at school and holding up signs on the first day of school referring to Delara. What's interesting is that order of protection was extended, I think it was ended up being in July, because I think they filed the motion like June 15th or whatever, because it was for a year. And I think they might have got a continuance. But it was either in June or July of 2017 that we had the hearing to extend this order of protection. And this playground incident, and me holding signs referring to Delara, was the next month. So she's trying to make it look like these behaviors, but these behaviors were not, they didn't have anything to do with the order of protection. There's nothing in the order of protection that says I can't decorate rocks and put free Delara on it and hope that the kids take them home and show their moms and dads, and then their dads will say, well, what's this hashtag, free Delara? Let's Google it. What's that all about? And find out about my case. Or maybe my daughter would see it, and because I had not, the judge wasn't enforcing she kept me on supervised visits, but we didn't have a visitation supervisor because we couldn't find a visitation supervisor. And the judge says, well, if you can't find a visitation supervisor, everybody agrees on you just won't have any supervised visits. So we didn't have any supervised visits until we got, the trial was in October. So in August, I knew my daughter hadn't been seeing, no contact with me since February. And the last time she saw me, I was getting, there was 3 policemen there ready to arrest me. So I wanted her to know I was still out there and I'm still working to get her home. And so I was hoping that and that's weird. I know that's weird. I know it's weird to paint rocks, and I know it's weird to go to the school and hold a sign that says children need both parents and free Delara Gadare. But I want the kids to see it. I was hoping Delara would see me and know I was still out there. And then people, my enemies say, well, that's psychologically harmful. That would be embarrassing to your child. And she might get bullied. Somebody might make fun of her because you're out there holding signs. But I'm like, no, she wouldn't. She would love to see me out there holding signs. That's what I was telling them. I'm like, she's not you, and she wants to know I'm out there and I love her, and I know she loves me, and I know she's not being treated fairly, and I'm trying to get her home and get her needs met. And so that was in August of, but that had nothing to do with this order of protection. So she tries to make it sound like it did. But about me holding the signs, because I had to do something, you know, going. My daughter's not getting any relief. So, and I'm running out of money for a lawyer because the way they keep dragging things out. So I had to do something different, because if what you're doing is not working, you can't keep doing the same thing and expecting different results. So I was trying to come up with some creative solutions, you know, try something different. And what's funny is on one of the supervised visits, I told Delara, I said, well, don't be surprised if, because she never saw me at school. The principal said she said she saw Delara looking out off the school bus, but I don't think Delara saw me, because she never said anything to anybody that she saw me. But I told her, I said, well, don't be surprised someday if you see me standing on the side of the road holding a sign that says, bring her home. And this was a supervised visit, and the visitation supervisor heard, and I wanted to know how would she react if she did see me, because I don't think she ever saw me holding the signs before. And she says, if I see you holding a sign like that, I will run up to you and hug you. And so she wants me to do whatever I can and stand up for her. And because I asked her, I said, why don't you tell people, instead of being mad and angry, I said, why don't you just tell people what you want and how you feel? And she says, when I tell people, they seem like they don't care, or they can't do anything to help. So then she acts out. Or now, this year, she's like turning all this pain inward and is saying, you know, she's just miserable. Her life is terrible and she wants to die. So, that's bad. And that's not from anything I'm doing to her. It's my absence in her life. It's people, it's from being deprived. And she knows I'm a good mom. And, children, you know, she knows she has a right to a relationship with her mom. And she knows it's not fair, and she knows it hurts, and she knows her dad she knows her dad's behind it. She told me on the phone call today, she said, Dad says it's your fault, you can't see me. And I didn't say, well, it's really your dad's fault. I just said, it's not my fault. And then she finally says, well, it's everybody's fault. It's your fault, and Dad's fault, and the court's fault. So, anyway, okay. All right, so she's trying to say that these behaviors of throwing rocks and holding up signs the first day of school, and holding up signs, that was constitutionally protected speech. There was nothing in the order of protection that says I could not hold up a sign, even with my daughter's name on it. And then after I did that, they got a restraining order against me saying you can't hold signs that's got your daughter's name on it. Which I think is, can't remember, because what Judge Robinson said, because they tried to put the exact same gag order on me in Third Circuit Court that I had overturned. I mean, word for word, the same gag order that they'd asked for in juvenile court, and they got overturned. And that hearing on YouTube, I've got that hearing where they're extending this order of protection and trying to put the same gag order on me, and I'm arguing with the judge and citing case law, and he's like, he's going to do what he wants to do anyway. But I think when he did the written order, he didn't write the order exactly like what he said in the courtroom. And they speak through their written orders, so I'm not bound by what he said. I'm bound by what he wrote, I guess. Okay, beginning in December of 2017, Mother had supervised visits with Latara Ballard with Progressive Families. And I like Latara. The very first visit, she's like, because she deals with people who really need their visits supervised. And the first time she meets me, she's like, why are you having supervised visits? And I'm like, abuse. It's just abuse. They're breaking the law. That's why. My daughter's dad hates me, and he's got a lot of money. Mother has had supervised visits with Latara Ballard with Progressive Families. According to Miss Ballard, Mother had been cooperative with supervised visitation and has been appropriate. Although she believes Mother is capable of having unsupervised visits, what she specifically said was, Latara, and this is on YouTube, is the child is not in any danger of harm from me. And that's what you're supposed to do. If you're supposed to meet that criteria. If you're going to order supervised visits, it's only supposed to be the child will be harmed or there's endangered if it's not visit. So Latara says, and Latara is very well-meaning, but she was concerned about Dolores saying, I don't like the visits, and I don't like the visits either. And when you look at it as being supervised, I want to see her not supervised, and I don't like the phone calls. I want to see her face to face. So I know she said was going and telling Dolores' dad that she didn't like the visits, and Latara was afraid. Well, she's saying things. She's throwing the mom under the bus and playing the mom and dad against each other, and so she said the child's not at any risk from the mother, but the mother might be at risk from the child because of some of the things the child says. But there's no provision in the law for the court to order supervised visits because the mother is might be not even endangered by the child, or the child presents a threat to the mother. There's nothing in the law. I'll take my chances. That's what I said. I'm not afraid of my daughter. I'm not afraid of anything she'll do or say. I don't want the supervision. I want us to get her, life back. Let's see. Based on the child's extreme behavior issues, and the child did not have extreme behavior issues. She never had extreme behavior issues with me. One time, one visit, when we started out in the study room at the library, and then it ended up we didn't realize it was reserved, so we got kicked out of the study room. Then we went to the children's library, and the librarian told us we were being too loud. So we moved. It was very disruptive. We had all these transitions during this 2-hour visit. And it kind of got on my daughter's nerves, and she went and after we got to the third place, she went and crawled under a table and got a little weird, but it was okay. I mean, I was a little, it was weird, but it wasn't. And well, Latara, because that wasn't like my daughter, but. And Latara's like, well, this is how she's like. This is what she's like all the time at school and with her dad, or a lot of the time. But it was weird. But she wasn't violent or loud or anything like that. It was just disturbing. It was a little disturbing. But it was a supervised visit, and we had all these transitions during it. It wasn't anything I did, and I didn't really blame her for that, but. Based on the child's extreme behavior issues, that is not even what Latara said. She didn't say. She was just concerned about some of the comments that Delara made might be misconstrued, or my daughter's dad hates my guts, and anything he can get to use against me, he will. So. I mean, if my daughter said something to me, and there have been a couple times she said something, and like she wanted me to sign a passport, and I just freaked out because I don't want to sign it because I'm afraid he'll abduct her, and he's like, oh, Dad says we'll only be gone a week, and it ended up being not what I thought it was, but I'm still not going to sign but but it was just something she said, and I didn't have all the details, and I ended up being wrong in my understanding. But it wasn't anything that affected, my visits or our relationship. It was just kind of upset me a little bit. And but I addressed this in the trial too about we don't need supervised visits. Based on the child's extreme behavior issues, but it wasn't. It was based on comments the daughter made that she was worried that it might get twisted. Ms. Ballard recommends that these unsupervised visits happen only when in-home services are in place. So that's one thing. And I've been in therapy for years. Since 2011. I started a few months before that. I started seeing a therapist when I was pregnant because I knew I was in big trouble and I didn't know how to handle it. And then after I had the baby, I didn't have counseling until he accused me. He made his first false report to DCS when he claimed I had bed bugs. My house was infested with bed bugs. I've never seen a bed bug in my life. And he said that my daughter was covered in bed bug bites. That wasn't true. And so that's when I had to start getting counseling because I couldn't handle. I just could not deal with this dysfunctional behavior, and I couldn't change him. But I was trying to get myself to where I could stay as healthy as possible. And then my daughter started counseling after this court interference. She started going to see a counselor, Dr. Berryman. She's still seeing her. But the father, and since day one, when that Sarah Rice Digby called me 4 years ago and said she'd just been retained, I said, he doesn't need a lawyer. He needs a therapist. That's all he needs. My daughter does not need her life turned upside down. And he just needs a therapist. That's what he needs. Nothing good will come out of him having a lawyer, and it hasn't so far. I keep thinking, well, maybe this story is going to be something like the story of Joseph in the Bible, where all these horrible, horrible things happened over a long period of time. There's a lot of suffering. But then in the end, you look back and say, oh, God, what these people meant for evil, God meant for good. And I'm holding out hope that there is something good is going to come out of this. But I've been in therapy nonstop. I changed therapists. I've been seeing the one I'm seeing now, May 2011, nonstop. And when I first started seeing him, until I really got myself to where I felt like I could handle whatever he wants to throw at me, I was going once or twice a week. And that's when I had good insurance. And but it's been hard. And like in 2013, I went and I said, I want him dead. That's the only way my daughter and I will be able to live our life in peace, is if he's, not here. And I'm really good at keeping check on my thinking processes, and I knew that was bad. So I'm like, I don't like feeling this way, and I'm so angry at this man. I feel like I hate him and I want him dead, and I don't want to feel that way. And it hurt, and I went to the elders at my church and I said, I'm in sin. I'm in sin. I hate this man, and hatred is like murder. Yeah, it's like murder. You get the same penalty for hating somebody. And I had to, but spiritually, and this was before he took me to court. So that's why when he took me to court, I'm like, I'm in the best I am in the best mental and spiritual, emotional health I've been in my whole life, probably. And he goes to court saying my mental health had deteriorated. And and then my therapist writes, the letter, gives to the guardian ad litem, and sends it directly to opposing counsel, and then, saying that I'm a competent, nurturing mother. I've been mentally stable for many months, and he has, I'm capable of making any decisions in the child's best interest and stuff like that. I'm a great mom, period. And he's seen me with my daughters, because when I went to on a session, and there wasn't anything that would be not good for her to hear, I'd take her with me. He's seen me interacting with her, and so he said that in his letter. And then they go and say, oh, the mother's, and he said I was exceptionally compliant with treatment. There's not very many people who make the kind of progress I made, and are exceptionally compliant. And yeah, because I'm probably one of his best clients he's ever had in his whole 50 years of being in the behavioral health field. So, them saying I'm mentally unstable is just, it's a lie, it's a misrepresentation, and they're violating their duty of candor, because that was not based on information or belief. That was just them ignoring the facts. And they were trying to say I was off my medication, even though, she's not compliant. And you can read that order. Read the order of the judge, and that's what she said. She says, oh, there's concern, the mother's not following her therapist's advice. She should be following it more closely. I can't follow it more closely than being exceptionally compliant. So that's what I've been dealing with. And the judge will just, anything they say bad about me, she goes with it. She just repeats it, word for word. I'm almost done here. Okay, based on the above findings of fact, which are not, her findings of fact are not based on, it's just crazy. And I'm going to break them all down. Cite the evidence, refresh your memory, and in this motion to alter amend. Okay, where was I? These pages are not numbered. Okay, here's the orders. Okay, those were the findings. Wait a minute. No, that's not it. Conclusions of law. Okay, those were her findings of fact. These are her conclusions of law, and her conclusions of law are screwed up too. Mother has asked to be named primary residential parent. The statute governing modification of an existing parenting arrangement with respect to custody, also known as the primary residential parent, provides, if the issue before the court is a modification of the court's prior decree pertaining to custody, the petitioner must prove by preponderance of the evidence a material change in circumstance. A material change of circumstance does not require, because they don't tell you exactly what it is, but you can go look in case law and see what has been considered a material change of circumstance and what hasn't. But see, we stipulated to a material change of circumstance, so she didn't have to make a finding of fact or a conclusion of law. She should have just, gone with it. I'm going to try to find some case law exactly on point with that. A material change of circumstance does not require a showing of substantial harm to a child. A material change in circumstance may include, but is not limited to, failures to adhere to the parenting plan, or an order of custody and visitation, or circumstances that make the parenting plan no longer in the best interest of the child. This court finds that there has been no material change in circumstances that would warrant a change in primary residential parent in this matter since the court order from October of 2015, even though we stipulated that there was. It is clear that the same issues that led to the father being named as the primary residential parent in 2015 still exist today. And you can read the original court order and my brief where I break down what she said and what was true and what was not true and right in her order. So the same issues do not exist today. And the guardian ad litem said, Miss Hubble is still Miss Hubble. And that's true. I'm still Miss Hubble. I'm still the same competent, nurturing parent that I was before all this started. And I'm not going to change my... it's just insane for you to say you cannot be yourself when you're a competent, nurturing parent and your child, all three of your children have thrived in your care. And, of course, my two older children was with a different father. I mean, my little girl's dad is the weak link in this. He's the one who's not getting counseling. But the in-home services through youth villages that Latara was asking for, that is probably the only therapy my daughter's dad will ever get. And it is court ordered, except it's supposed to be voluntary. So, but he'll do it. He said he would do it. He said he wanted help with him and his daughter. So I'm glad for somebody to have some kind of support for him. And I hope at some point he'll understand that Delara needs me in her life. That might not ever happen. But for them to say the same issues that led to father being named as primary parent in 2015 still exist today, that's not true. For one thing, the order of protection's not... I've made a list. I'm going to have to write them out. But my daughter is doing horribly. There's no order of protection. Same issues. I don't know what issues. Oh, she complained about the child slept with me because her room was too cluttered for the child to use. So I cleaned out my daughter's room, took pictures to the court, and so that's a material change. And as far as my house goes, DCS came to my house, and they never said my house was unsafe, or I did make them get a court order. They filed a petition for neglect and dependency to get a court order so I could, and I went and talked to the judge, and I finally agreed to let them in, and I wished I had not. Because I got my day in court, and I thought, well, if I give them a hard time, it's gonna delay the custody trial. I didn't want to do that, so I do regret that decision. That's one decision I've made that I regretted, is saying, okay, I got my day in court, and I see that in the petition for this, they're saying, they're telling the judge. I mean, they told the judge some bad things, but they told the judge, I did say the father's using DCS to harass me. That was that was in the petition, and that I did say this is a violation of my. I'm going to require you to have a court order before I let you in my house. So that that I was glad that, and then I'm like, okay, this got they acknowledged this, that so go ahead and go through my house and we'll be done with it. And so they came, and this is before my custody trial started. So they came, they didn't find any threats to my daughter's health or safety. They withdrew their petition, and I did have a court-appointed lawyer for that one hearing. So they withdrew their petition, and then they were out of it. But after the trial, it was April 2015 when April or May when we started that custody modification trial. So DCS was not involved at all. The entire because the spanking incident had happened before the trial started. So they were not a petitioner or intervening petitioner during the trial. But because they had to petition at some point while, the petition was waiting on the trial, I guess they took that to mean, well, we can make the we can ask the judge to order supervised visits, and we can have DCS pay for it. And I said, no, you can't, because the same statute that says y'all don't have authority to restrict me to supervised visits also says you can't have DCS pay for it unless they're the petitioner or the intervening petitioner. So, and DCS agreed with me, because after several months, they filed a petition for relief. And the DCS lawyer came in and said, Your Honor, we can't do this. It's against the law. And if I had heard about this, realized this was going on, I would have filed for relief a long time ago. But I told DCS what they were doing. I don't know if they can say it just didn't get to the right person, but I just sent it to like customer service, and I said, whoever, make sure this gets to the right place, because I don't know who to send it to. But they've been given an unlawful order. So, yeah, so the judge acknowledged that she broke the law and gave DCS relief. So I said, okay, go ahead and follow the rest of the statute and relieve me of the visitation supervision, since there's no evidence whatsoever to show that my daughter will be harmed if my visits are unsupervised. And then, but the judge wouldn't do that. Okay, so she's claiming that everything's still the same. And they're not. We have had material changes of circumstances. And some of the things have changed. Although the child's behaviors have increasingly become worse over the years, and she acknowledges that, but she claims it's only over the years since I've started my supervised visits, which is 2 years. Almost 2 years ago. Although the child's behaviors have increasingly become worse over the years, there still has not been a showing of a material change of circumstances. And I believe I can show like 5 or 6 or 7. And that's what I'm going to do in this motion to alter or amend. The mother's actions continue as they did prior to the previous court order. What specifically is she talking about? I'm not discussing inappropriate things with the child. I didn't really do anything wrong anyway. Oh, yeah, she was trying to say I was less likely to encourage a close and continuing relationship between the child and the other parent. I need to go through that order. I will read through that order again to see what she's referring to when I do my motion. This motion to alter or amend is probably going to be 20 pages long. Okay. The mother's actions continue as they did prior to the previous court order. Therefore, these factors do not constitute a material change in circumstances, and thus father must remain primary residential parent. And that is really screwed up, to say that my daughter fallen apart after I'm cut out of her life. That in itself, and I believe we can prove that, that's a circumstance that makes the parenting plan, the custody arrangement, not in the child's best interest. But I'll get this all written down, and I will. I've got like 3 weeks before I have to file a notice of appeal, and I'll do my motion to alter or amend before that. Give her a chance to fix it herself before I do the appeal. In order to modify a parenting plan, the court must first determine if there is a material change of circumstance in affecting the child's best interest. And it's basically the same thing. There's to change the to change the primary residential parent is a higher standard of proof. In order to modify a parenting plan, which would be like parenting time, the court must first determine if there is a material change of circumstances affecting the child's best interest. Material change of circumstance does not require showing a substantial risk of harm to the child. A material change of circumstances for purposes of modification of a residential parenting plan schedule may include, but is not limited to, significant changes in the needs of the child over time, which may include changes related to age, significant changes in the parents' working or living conditions that significantly affect parenting, failure to adhere to the parenting plan. And see, we've got him. He went 2 months disobeying, failing to let me have supervised visits. Even supervised. Even though I felt like they should be unsupervised, he refused to let me have any visits, which was disobeying the court order, which she never mentions in this, which is evidence of her bias. In this case, the exact same issues that existed prior to 2014 are the same issues currently. We didn't have any proof that he had disobeyed a court order before. We've got that now. That it's a court order pertaining to my relationship with my child. He's interfered with my relationship with my child. There's been no additional proof that anything has changed or the needs of the child has changed. I believe I can show she's wrong. This child has significant behavior issues. However, she has been struggling with these issues since before 2014. That's not true because, like I said, the psychoeducational report she had done June 2014, there were no issues with her behavior. The preschool, no issues. Church, Bible class, no issues. Me, no issues. Having found no material, I'm going to go 4 hours. I'm fixing to have to stop this again. Having found no material change of circumstance, the court finds the previous custody order will remain in place. However, in the previous order, mother would be allowed to exercise unsupervised visitation once an agency recommends it. In this case, Ms. Ballard with Progressive Families has determined it would be appropriate for mother to have unsupervised visits as long as there are in-home services in place. And they are in place. They're in place with Delara and her dad. Therefore, the court will allow, unsupervised visits on a gradual basis. But, so, you think she's throwing me a bone? Beginning May 1st, 2018, the mother may have unsupervised visits on Sunday mornings from 10 to 1 p.m. I'm going to stop this and start again.